Good morning, friends. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Thanks a lot. As you know, we are doing this entire series on new labor code, which government has proposed. Though there is a central government announcement, but still, state government has yet to work out regulations and even central government. But certain part is already implemented. In view of this, we have done. And today is the last session for this labor code series. Today's topic is New Labor Code 2025, Series 4, Occupational Safety, Health and Working Conditions Code 2020. Today's presenter is Ms. Kinjal Mehta, Senior Associate Mehta and Mehta. And today's panelist is Mr. Sandeep Nagarkar. Welcome, Mr. Sandeep. Thanks for your time. Thanks a lot.
Thank you.
Mr. Sandeep Nagarkar is a practicing company secretary and with over 20 years of experience and commerce graduate, master's degree from law from Pune University and founder partner of KNP Associate and GPSA Associate LLP. He was associate with leading corporates like Kirloskar, Tech Mahindra and others and is having a different experience in corporate law and industry and labor law. His competence include in advisory execution support for labor law and representation before labor authority government bodies. He is acting as an external member of internal committee of POS laws. He is also POS certified professional, served as a chairman of Pune chapter of ICACI and contributed to various publications and investor awareness program. Welcome, Mr. Sandeep. Thanks for your time.
Thank you.
Our today's presenter is Ms. Kanjal Mehta. She is a chartered accountant and company secretary. She has an experience in E&Y assurance, auditing prominent private sector banks, contributed to M&A transaction in EY strategy and transaction advisory team. She also worked with Black Soil Capital, a venture debt fund, underwriting investment in growth companies. Currently, she serves as a senior associate in Mehta and Mehta's IPO team. Our panelists, other panelists, you know, Mr. Moderator, Mr. Bala, who don't need any introduction. Welcome, Mr. Bala. With this, I'll request Mr. Sandeep. We thank all our panelists today's webinar for joining us on our knowledge sharing journey on behalf of entire team of Mehta and Mehta. I'll request with this, without losing the time, to start the presentation. Mr. Bala will straight start the presentation. And I'll just say that people request all the people, participants, to put your questions in the chat box and permitted time will allow you to speak. So I'll request Ms. Kinjal Mehta to start the presentation. Thanks a lot.
Yes, hello everyone. I hope my screen is visible.
Yeah, very much.
So we are coming to an end of our labor code series, and today is the final code that we're taking up, which is the Occupational Safety, Health and Working Conditions Code 2020. Now, this is the last code in the four codes that the government came out in November of 2025. And again, it giving you a brief on how we have come to today when it comes to Indian labor laws. So as we know, before there were 29 labor laws which have now been converted to four labor codes, three of which we have already covered in our webinar series, and now this is the fourth one. It is labor law is governed by central and state governments. So there was a requirement for streamlining of statutes to not have overlapping provisions, requirements that would just be a burden on establishments in India. There were a lot of requirements under various statutes, a lot of registrations required, different returns filing under different statutes. It just created a lot of unnecessary compliance requirement under the labor laws in India, and it was just becoming a burden. You had inspectors coming in, they called it the Inspector Raj, which was very individual centric. There were no kind of streamlined processes and maintenance of specified registers required. There were register maintenance requirement under different statutes. It was all very segregated. The laws that are now some of the laws which are now kind of codified into four labor codes are your Minimum Wages Act 1948, Factories Act, Contract Labor Act, Payment of Wages Act, Employee Providence Fund Act, and um, 22 other laws which have now kind of come into four labor codes. These four labor codes are the Code on Wages 2019, the Industrial Relations Code 2020, the Code on Social Security, and the fourth one, which we are covering today, the Occupational Safety, Health and Working Conditions Code 2020. Now, this fourth code has replaced 13 different acts. These acts include Factories Act 1948, Mines Act 1952, Contract Labor Act 1970, Interstate Migrant Workmen Act, Plantation Labor Act 1951, Working Journalists, Dock Workers, Building and Other Construction Workers Act, Motor Transport Workers Act, BD and Cigar Workers Act, Sales Promotion Employees, Cine Workers Act, Working Journalists Wages Act 1958. As you see, some of these acts are pre-independence even, which defeated the purpose of the requirement that is required in the market today. As I mentioned previously, there were fragmented laws. Like I mentioned, 13 different laws which have now been codified into one law. A lot of overlapping happening. There was a lot of inconsistent definitions under various acts, for example, workers, for example, wages. All of these definitions kind of clashed, overlapped, and created a lot of confusion for establishments in India. This resulted in a lot of lapse in compliances, inspectors creating a lot of difficulty for establishments, a lot of just a lot of burden on the establishments in to allow for compliance with the labor code before 2025. There were requirements for multiple registrations under different acts, which have now kind of converted to only one registration. There were various different thresholds, various worker limits for coverage provided under these codes. Various requirements thresholds were fragmented, different for different types of workers, types of establishments, and that overlapped and also created gaps in terms of coverage when it came to different industries, different types of establishments, etc. There was separate enforcement under different statutes. So you had inspections under one particular act 1 month, inspection under another particular act another month, which just created a lot of nuisance for establishments and businesses in India. There was poor safety culture requirement in India. It was more post facto and not preventive in nature. It was more checklist related, and it just didn't serve the purpose and the requirement for the protection of the employees. There was limited sector coverage. Services and informal sectors were excluded. We will get more into this later on. But this code has essentially drastically increased the coverage for compliance under labor codes in India today. It has also given more coverage to vulnerable workers such as migrant workers and contract workers, which weren't covered before. There was, like I mentioned, a lot of redundant registers, maintenance of information in physical format that even that didn't serve the purpose and was very outdated for the requirements of the industry today. There were weak health standards. There wasn't really much focus on occupational health hazards. And even if there was, it was focused on only particular industries. There wasn't kind of a universal health coverage for all employees in India. Also, the penalty structure was outdated. The penalties weren't updated to the requirements of today. There was also very prosecution and criminal centric framework, which resulted in a lot of cases being piled up in the industrial tribunal, which never used to get resolved, and that kind of didn't serve the purpose of the labor law framework, which is required today. A lot of outdated policies and safety norms were codified. For example, safety for women, which where women weren't allowed to work after a particular time, which has now kind of changed in this act, where now safety for women is mandatory and they are allowed with their consent to work as many hours as men. So yes, so these were the different issues that were being faced before the Labor Code 2025, which this Labor Code attempts to kind of change and update for today. So we will quickly just run through the changes when it comes to compliance requirement that have taken place under this code. So, like I mentioned, so coming to the regulatory structure and applicability of the code, we saw the number of laws. 13 different laws have now been consolidated into a single code. The thresholds, like I mentioned, were multiple, inconsistent, have now been rationalized, and they are kind of uniform over all the codes. Then hazardous processes, this was limited to only certain acts, but now this is the scope has been widened to cover all establishments, having the required threshold, that is 10 employees that are covered under this code. Then you have sector coverage. So before, you had occupational safety requirements for factories, mines, these kind of sector specific laws, which has now been kind of opened up for a universal establishment coverage. So we can see that there is a wider net and wider coverage of way more entities that are now covered under the labor code compliance requirement. The liability and accountability framework. So
Not only that, because the new labor code, what it has done is, as you said, actually, earlier there were almost about 13 labor laws. When the 13 labor laws were there, multiple registrations were actually called for. There are a lot of procedural hurdles was there. So now what the law has done, it one single registration. That also now the word of digital, only electronic registration, single registration will be done, getting away all the multiple registration. That is one thing. And second thing is, as you rightly say, in each of the regulations, there were multiple returns. That was also there, which was actually, time taking. Again, as you said, inspection, various inspection. Those days, I remember we had to maintain the inspection notebook. Whenever the inspector comes, he has to produce the inspection notebook. All those things were there. Now, probably much simplification has taken place. That is one thing. Second thing is, there you are anyway going to discuss that penalty issues. Decriminalization has been done in many of the issues that you are anyway taking up. Yeah, go ahead.
Yeah, just Mr. Bala, I just want to add one thing what you have discussed. That the single registration and license you have mentioned, they have made a very fantastic provision saying that now a contractor can have common license. Suppose he's engaging into different activities like providing of contract labor, BD, cigar, and any other activities. He can have a common license if he's providing PAN services, and the license can be valid for 5 years now. So this is the provision they have introduced. Like every year, we need to go to the labor authorities, to renew the license. We can have common license that is valid for 5 years. And another important point I would like to add over here, like the code is covering workers in the unorganized sectors. So typically, they are working on the database, and all the claim will be processed based on their Aadhaar card number. So more and more employees will be covered under Social Security as well as this OSH code. So benefit will be given to people who were deprived of these benefits earlier in the old labor laws. Yeah, thank you, Kinshal. You can go ahead.
Right, correct.
Thank you.
Yes, coming to liability and accountability framework from what it was before. So now the ultimate liability has been put on the ultimate employer, regardless if you're hiring contract employees, interstate migrant employees, etc. Where previously, if for example contract employees were there, it was when you're outsourcing work, you were kind of outsourcing the labor law requirements also to your contractors for the contract workers that you were employing. But this is changing under this code, where the ultimate employer is essentially responsible for compliance, for labor law compliance for the contract employees also. So this is now turned into a shared ecosystem of compliance requirements, with the ultimate liability falling on the employer. So that's a major shift. Then previously, designers, architects, engineers of various infrastructure that is provided to employees in the workspace to work in, the designers, architects, engineers did not have any liability when it came to what they were providing and safety requirements. But now, under this code, designers, architects, engineers have also been kind of covered, where they are also required to do compliances under this labor code. Again, I failed to mention manufacturers, and importers, where there were before peripheral obligations, but now even these parties are required to take accountability for the machines and the infrastructure that is being provided to the employees. So the occupational safety risk has now been extended beyond the payroll of all the employees that are there on the payroll. It is beyond that, and also it is kind of put the accountability for the safety of the employees on all parties that are involved in the entire ecosystem of the company. Coming to the philosophy of the code, before it was the compliance style was more prescriptive, checklist based, and kind of you're following it to just the word. But now you're required to follow it to the spirit, where it's more risk based, it's more preventive. Your safety focus before was more reactive, post incident, etc. But now it is required to be more proactive, starting from the design stage itself, of the workspace, of the machines, articles that are provided by the employer. Then the hazard identification was very limited to limited sectors, limited establishments. But now hazard identification is mandatory and continuous for all establishments that to whom this code applies. Worker
No,
participation.
when you talk about the hazard, there's one thing I noticed also in the code. Earlier, the hazardous was actually depending upon the nature of the manufacturing, like, dangerous chemicals and things like that. It was like that. Now, what the code says is, if the work itself is deemed dangerous to the health of the employee, that is the word it is actually used in the code. If the nature of the work is deemed to be dangerous to the health of the employees, then the employer is really required to take a, specific safety requirements, etc., and other thing, and not the interest of the safety, health of the employees. That is one thing which has been brought in this code. That is one. And the second thing is we have been always talking about equality, women empowerment. We have been actually talking about it. But really speaking, this code is greatly addressing the equal employment. Because earlier the women were actually prohibited in many of the areas where they are not allowed to work. Now the code actually visualizes the woman can be employed in any of the areas. That is one. And second thing is very specifically what they have brought in is women can also work before 6 a.m. after 7 p.m. provided the employer take care of the safety and the transportation and the other things what are required in connection with that. That is one great change, really, when we are talking, especially, we are talking about the Viksit Bharat, we are talking about equal opportunity for everybody, we are talking about the women empowerment. Greatly, this code is actually addressing. That's what I think Sandeep may like to add on this.
Yeah, see, sir, I agree what you are adding this point. Basically, the intention of this code is, to provide environment which is free from hazards. So this is the basic theme of this code, that we have to provide an environment, or we have to create a facilities where our atmosphere which is free from hazard. So the health, safety, and welfare, these are the basic bedrock of all the labor laws, and OSH code is not the exception. So this code is basically branding the gender parity. So earlier, as you rightly mentioned, women were prohibited in few operations in factories. But if you see the code, it is now permitted to, they work in all type of job and round the clock. So even women can work in night shift as well. So this will provide them to opportunities to work in high paying jobs and to earn income for their families. So this is typically a gender parity, what they have tried to achieve under this code. And these are some welcoming provisions in the act. And we always read the act from the first page. But now, if you see the penalties that have been provided under the code, so one should refer the code from the last page where we have offenses penalties, because the penalties, they are really high. We can say 10 times than the providing our earlier outdated labor laws. So here, if you see the OSH code, the penalties are ranging from 1 lakh rupees to 5 lakh rupees. So, and there's one more provision about this penalty is like the amount can be used in case of a death or bodily injury to the workman. So really, they want to extend the benefits of this penalties to the victim. So they are caring about the health, they are caring about the safety, they are caring about the working conditions of the working people under this code. Thank you. Kinjal, you can go ahead.
This is very unique, huh? That this penalty, otherwise, like in Companies Act and everywhere, it is in some fund. But the
Yeah.
same where to use actual
Yes, yes.
utilization. But I may ask you question. They are
Yes,
telling
madam.
it can be utilized
Yeah.
for workers,
Yeah.
benefit. So
Yeah.
who will decide and who will pay that?
The competent authority, madam, the labor officers, we call them as GLO, government labor officer. Typically, they are the authority, and the law code has provision which says that 50% of the fine amount can be used for the victim, and in case of a death of an employee, the amount can be given to the legal heir of that concerned deceased person. This
It's
is
very
employed.
good, very good
Yeah,
amendment.
yeah. So I thought I just add this here.
Yeah, thank you.
Thank you. Yeah. Kinjal, you can go ahead.
Further, one more thing that is new in this code is, before there was not really any worker participation when it came to compliance with the labor code, etc. All they could do is sue the employee when these things were not followed, when labor law compliances were not followed by the employer. But that would not result in much because of the court system and the adjudication system that was available for resolving cases in India. But now that has changed. If the worker feels that there is any hazard, if he feels there is imminent danger, if he wants to know more about uh, different practices in the factory, in the workplace, etc., they have the right to report incidences where they feel there's imminent danger, there's hazard, there is things are not functioning the way they should under the code. Then they can report this to the inspector cum facilitator for the establishment. They also have the right to know and right to information of various practices in the factory, in the workplace, etc., which is a big shift when it comes to employee empowerment under the code. So now the perspective, they're trying to change from a clerical checklist based compliance requirement to more of a risk management function as an organization.
Kinjal,
Then
there are questions on the chat box. Shall we take
Yeah.
now?
Yeah. Sure. Why not?
Because if you are, see, there is one question called are non-profit organizations engaged in providing training to unskilled persons by posting them to corporate entities for the job training and paying stipend during the training period could be considered as employer as a person carrying training services and stuff? Yes, that is the answer. See, the labor code typically, or the labor laws, they are governed by the relationship of employer and employee. Okay. So they are not going by the objective of the organization. So even though you are a non-profit organization, you need to register under Shop and Establishment Act. And as you're providing training as you are, as a service, so you will be covered under the code.
further,
Yes,
Further,
yes.
I would also like to add that when it comes to the applicability of the code, the key definition is an establishment under this particular code, which we will get into later. So where you'll get more clarity on, there's a special, clarity on non-profit organizations, etc. So you might just want to wait for that and get more clarity when it comes to that.
Yeah, you are right actually, but there is only one thing is there in this code, because this questions is a little confusing, because they are saying job training. That is one thing he's saying. Second thing is he also training unskilled people who are actually positioned or something like that. The question is not clear whether it is the employee-employee relationship. Because what happened, there is one act called the Apprentice Act in 1961. So this code categorically say the people who are covered under the Apprentice Act as apprentice or trainees. That is the word which is actually used here. They are very categorically exempted from the category of the workers. Now with this particular question, we will not be able to answer the clear-cut answer, because the question is not very, very clear to me, according to me. Because one side you are taking unskilled people, second side you are taking providing training, and other thing is a little confusing. But the only thing is, by looking at it, if the person is actually employed under the Apprentice Act of 1961, he is working either the trainee or providing as apprentice or whatever it is, then he does not come under the category of the workers. That is the thing. Otherwise, he is covered. That is very categorical there. Anyway, you are going to discuss this actually. And another thing is, there is somebody has put a question, can we get a presentation? We have been telling n number of times in the past also, now also. Presentation is not actually made available, but only thing is the recorded webinar will be disseminated via YouTube, and which is accessible to you, which contains the webinar. You can always have it. It will be disseminated in about 2-3 days time, like that. Second thing is, do we need taking any permission from the authorities for the women applying working before 6 a.m. after 6 a.m.? There is nothing. It is only the women consent is required very clearly. That is number one. Number two is the employer has to take all the necessary safety and transportation, etc. and other thing. That is the only requirement. There is no specific permission or something like that. That is actually not there. Then the total penalty to be used for the workman, or 50% of the penalty is the, okay, this is this thing, comment against me actually. Earlier factory was after, so what about the code also state, or what is that? Earlier the factory was state. Was that about the code also, wise or not? See, really speaking, this particular factories act actually coming in the concurrent list. It is actually monitored by the central government or the state government. In the past also it is the same, now also it is the same. Because the central government actually put a central factories act. But the respective states, depending upon their area, geography, their local customs, etc., and all this, they formulate their factories act. So there is always a state act there. But the only thing is, yes, law is central, as our Sandeep said actually earlier. the state laws, state rules, that is being implemented separately. That is why the central has already notified the rule in the beginning, is set actually, and that is under the comment for the public. But at the same time, many states are enacting the rules. Most of the states are actually ready with the rules actually. Probably that will be notified. Till such time, the current rules will be maintained, that will be prevailing it. Till the new rules are notified with the respective states, that we will have to give an implementation to that. And according to the published news, these are all expected to see the final shape of the form effective from 1st of April. But there is also a misconception. The effective date of the implementation of this code is 1st of April, which is a misnomer. That should not be the case, because this, on the 21st November, when the labor law has been actually notified, that has already come into force. That is the thing. To add to the discussion, the apprentice can be registered by the establishment under the central NAP scheme and avail the stipend satisfactorily. Yeah, this is a comment. Yeah, you are right. That is all, I think so.
Right. So coming to inspection and enforcement, what's the change there? So before there was the inspection model was inspector centric, where the inspector had a lot of discretion on which establishment he wanted to go to inspect. It was not very pleasant for establishments to deal with such inspectors. Because they had a lot of power to do a lot of unnecessary things, which just wasn't, which created nuisance for a lot of establishments. But now we are looking at a model that is that places the inspector in the role of an inspector and a facilitator, where first he plays the role of advisory, allowing an opportunity for corrective action, allowing providing establishments with the guidance to comply with the labor codes, and then he can go about his inspection duties, um, uh, any kind of dismissal, any kind of uh, uh, going through documents and all that are required. He still has those powers, but at the same time, he is also required to first provide advisory corrective actions to the establishments. This is a big change, and we are hoping that this kind of reduces the nuisance that the inspections and enforcement created for various establishments. Also, documentation was earlier in physical registers, which have now been switched to electronic records. Also, the inspectors, like I mentioned, they had the discretion to decide which establishment they wanted to go to and inspect. But now it's the process is more digitized and randomized, which kind of takes away the power that these inspectors had. So we're looking at lower harassment risk, but higher documentation and discipline required under the code. Coming to contract and migrant labor, like we have mentioned in our earlier webinars also, this was a contract labor, migrant labors weren't covered appropriately previously. Interstate migrant workers had a very narrow definition, but now they are properly kind of ironclad covered under this code, where they require registration. Anyone employing such interstate migrant workers are required to follow certain requirements, which we'll get into later in the presentation. The principal employer has the ultimate duty, and when it comes to compliances with respect to the interstate migrant workers he is employing. Welfare obligation was pretty fragmented before. Now it's more codified. It's there's more clarity. Then interstate migrant workers could also be contract laborers, contract workers, where again institutions used to outsource the compliance requirement when they outsource the work to contractors, which is now kind of pulled back, and the responsibilities put in the ultimate employer.
Can you take the question, Kinjal?
Yeah, sure. Why not?
So
Sure.
they are saying, I have an organization, I contract with agency who provides skilled employees on their payroll to my clients. In such case, I bill to my client for providing manpower. and agency bill me to provide the skill set employees to my clients at agency role. So in such case, who is responsible to maintain the POSH policy, take registration under the labor law? See, if you're basically if you see the definition given of employee, it includes direct employee as well as indirect employees. So from the code perspective, there is no difference between direct employees and indirect employees. Now, if you are providing employee to your clients through some agency, you become a contractor, and the code is equally applicable to you. So based on your number of people that you are providing or you are hiring, then you will be covered under the POSH policy, or you have to take a registration. For example, if you are having 10 or more people, then you should register under the code. Then you have to cover under the register under IR and various code, because the threshold limit is 10 under all the code.
There is somebody is actually putting a question: do we need to amend the model standing order for the woman working in the night shift? It is not only women working in the night shift or something like that, but the model standing what you have in the earlier act will not be valid, because in light of the 50% rule, other safety requirements and other things, etc. So you need to actually entirely look at it. What is the thing with respect to the organization? I think the model standing order will call for modification, amendments, etc. That will definitely call for actually. Because earlier act, whatever the model standing order, it was based on earlier labor laws. So now everything has been unified here. You have to modify it to suit the current regulation. You have to certify and you have to get it there. There was another question about the Shop and Establishment Act. Shop and Establishment Act being an act which is regulated by the state government, the labor law is actually out of the purview of the Shop and Establishment Act actually, because that is in the state list. It is not in the concurrent list. So currently the labor law, what is notified by the central government, does not cover the Shop and Establishment Act. You have to comply with whatever the state law requirement is there. Maybe over a period of time, we'll have to wait and see, because they are also concerned about it, that we'll have to wait and see what is going to happen actually.
So I would like to add, Mr. Bala here. The code has, subsumed only 29 central laws, and they have not touched the independent laws like POSH Act or Apprentice Act. They will be applicable as it is. But there is a, industry reaction that now the 4 code, the company or the establishment has to comply only the 4 code. It is not the case. You have to comply with the 4 code as well as a respect to state legislation like Shop and Establishment Act, Maharashtra Labor Welfare Fund Act, or Profession Tax Act, or various other independent laws like, POSH Act. They have to follow. They have only subsumed the 29 different central laws. They have not touched upon the state laws. So I would like to, they are independently applicable to the establishments.
Yeah, absolutely, you are right actually.
Yeah.
As your total penalty can be used for the workman welfare of 50% of the penalty, either 50% penalty means pertinent to organization or with the penalty imposed.
Penalty imposed.
Yeah, there is nothing, because whatever the penalty is collected, total penalty, out of that 50%, that is the limit they said, it can be actually utilized. Earlier also he explained over the authority, over the approving people, etc., other thing and all, but it can be utilized towards the victim who are actually injured in this particular case. That is what the provision is there. This is a new provision which has altogether come. Not only that, and one more thing is there, for the first time, I think in the labor law, we are seeing the history, the compounding provision has been actually made. I think anyway, Kinjal is going to discuss that in the future, because compounding provision, which was not there earlier, now the compounding procedure has also been added in this.
Mr. Bala, we should not do, we have first session experience, let the session go.
Okay.
Otherwise the question, we will not able to do this now.
Okay.
Take 1 or 2 in between, otherwise that, otherwise let the session complete and then we take. Because in labor code, we have experienced a lot of questions come.
Yeah,
and otherwise up to 2:30 it will go.
That is right.
Sorry, panelists, but this happened in our first session and we were not able to complete. So that's why we are doing this.
Where we were more than 500 participants were there.
Yeah, that's why. Okay. Yeah.
If the gig worker is working with the employees found a road accident related to the hazard, also with the impossible for penalty and security. I do not know what is this.
Yeah,
actually.
no, Mr. Bala will start with the session only. Let session over and then we'll take the question.
Correct.
Only panelists can give and you can give expert comment in between, but let the question take lead, because once we start questions, 5 questions on the same topic you may get add-on. So then it
Okay.
is become too much. You will not predict how much time it will take.
Okay,
Okay.
so we will take only if there is a personal, a pertinent comment,
Yeah.
only we'll add, otherwise we will continue.
Yeah, sure.
Yeah, otherwise, and question will take at last. Sorry,
Yeah.
participants, but we have to manage the time also. That's why. Thank you.
Correct.
Thank you. Yeah, Kinjal, start.
Kinjal, you are mute, I think.
Sorry.
Yeah.
So coming to hazardous processes and high-risk establishments, when it came to monitoring and governance required, when it came to hazardous and risk-oriented workspaces, it was very sector specific. It was very limited in nature. But now the scope has kind of been opened up to a lot of other establishments where requirements are mandatory and continuous, and it's not as sector specific, but it's statutorily embedded for all establishments that kind of meet requirements and risk specified risks under the code. Emergency preparedness was very inconsistent under different acts, different requirements. But now, under this one code, there are just mandatory systems that are in place. Workers didn't really have right to report when they felt there was an immediate danger to their lives, etc. But now they are more protected under this code, where they have the right to report, they have the right to ask for conditions, for information and training when it comes to their work. So now, this code, we're looking at zero tolerance zone for governance lapses when it comes to the safety of the employees and the workers. Coming to penalties and enforcement consequences, like we mentioned before, there was criminalization before, which is super high for even minor lapses. Now the penalties are more rationalized, where a lot of decriminalization has happened. Monetary penalties didn't keep up with the inflation and the requirements of today, but now they have been significantly enhanced. Imprisonment and all was common before, but now it's not so much under this code. It's more monetary penalties that are being imposed. Joint liability was limited, but now when it comes to principal employer, contractors, etc., it's explicit and enforceable. There are compensations provided for places where it's a first time offense, but for repeated offenses no compensation concessions, is provided. Also, the concept of compounding has been introduced under the labor code, which didn't used to exist before, like Balaza mentioned. Then coming to governance and board oversight, it was more of an operational issue before. The role of the board was not uh, uh, explicitly provided in the acts. Before, it was more court judgments that dictated what the level of involvement and responsibility was there for the board. But under this code, board is expected to, being the principal employer, expected to look into the requirements under this code. Risk committees, again, like I mentioned, it was more of an operational issue rather than company board level, committee level issue. Now, under this code, we can look at ESG integration, which wasn't there before, and coming to reputation risk of the country, a company, etc.
One thing is there, Kinjal, here, when you talk about the board involvement, there are two things which has happened, because prior to 1996, what used to happen in factories, they used to appoint for the namesake a person as a manager, etc. If anything goes wrong, he has been made as a scapegoat. That used to be the case. But 1996, what has happened? There's a landmark judgment has come from the Supreme Court. It has happened with JK Industries versus Chief Inspector of Factories, by which they have recognized the factories, which is being a very important place with the hazardous things, etc. Another thing and all. They have actually brought in only the board member, that is a director. He can only be a responsible person termed as an occupier for the factories. That is what it is actually said. If they are not named anybody, all the board members, they are responsible. That was actually there. But even then, some more other, the supervision and other thing and all, which was not happening, people used to still appoint the manager. They used to say ultimate responsibility rests with the director, but the day-to-day responsibility happens like that and all, they're all managing it. Now the code actually thrust upon a more accountability, more responsibility, finally with the board levels. That is what it is actually, code is now aiming to do it actually. Not only that, those days it was, as you rightly say, there are 13 different acts were there. It was only under the Factories Act. So rest of the other things are all there. They will not be able to. Now the code has been combined, all the acts together. Now ultimately what happened, board will become totally responsible for ensuring the safety, health, environment, other things. That's what it has happened in this.
Now we are just looking at, so as they mentioned, we are trying to, as the government, when they are coming out with this code, they are trying to tell us that we're trying to streamline processes, remove the burden that different establishments have when it comes to compliance under labor code, etc. But let us just kind of see whether it has actually resulted in an easier doing business, or the compliance requirement is actually increased under this code. So there are both there are arguments for both cases over here. So when it comes to procedural compliances, before it was very high. You're looking at physical maintenance of registers, different inspectors under different acts, etc., which has now been reduced with when it comes to this particular code. Also, you're looking at a reduced number of returns, one registration, one license, etc. So we're looking at better compliance management here. When it comes to substantive safety duties, when it comes to an employer with regards to its employees, before it wasn't as kind of codified as it is right now. So we're looking at substantial increase in responsibility for an employer when it comes to this code. Documentation quality, before, like I mentioned, of physical registers, various registers under different acts, etc. But now, as much as this particular code requires documentation to the T, and there are high penalties for not maintaining documentation, this has been made more electronical, more streamlined, and the quality of documentation has kind of increased when it comes to this particular code. Then, when it comes to design stage compliance, this was very minimal before, where the designers, engineers, architects, importers, etc., didn't really have much responsibility when it came to labor compliances. But now this has been codified and it's mandatory under this code. So let's look at stakeholder-wise employer. The risk shift has been substantial. Way more establishments have been now included when it comes to compliance requirement under the labor code. Board and directors, like we mentioned just now, where it was more of an operational issue when it came to labor law compliances. This has now turned into a board level issue also. Designers, engineers, etc., weren't really covered before, which are now covered under this code. Manufacturers, importers, again, were not covered, now covered. Contractors, which is a major shift. There are special provisions under this act when it comes to compliances by contractors and employers engaging with contractors. So coming to scope and applicability under this code, when it comes to applicability, the code specifies that it is applicable to any establishment that has 10 or more employees in any industry. So it says that it's an establishment which primarily refers to any place where industry, trade, business, manufacturing, or occupation is carried out. That has 10 or more workers that are employed, um, including motor transport undertakings, newspaper establishments, audiovisual production, plantations, building and other construction work, etc. So So all establishments having 10 plus workers have been included. And previously, where you had your films, your newspaper establishments, etc., which were covered under separate acts, there was a lot of fragmentation and things over there. This has now been specifically included under this code. Any factory, so when it comes to a factory, the any factory with 20 plus workers using power and 40 plus workers without the aid of power are also uh, covered. So this is for a factory, but factories are also establishments. So all factories having 10 or more employees are also considered establishments. But when you're looking at factory related compliances, you're looking at an organization being called a factory under this code would be 20 plus workers when it comes to when it's using power, 40 plus workers without the aid of power. Then there are certain inclusions under the code where no worker thresholds are applicable. If you're running an establishment, you can even under this specific category. Then even if you have one worker, this code applies to you, which is your mines, ports, any kind of hazardous or life-threatening activities where this 10 worker threshold has been waived off. Now, coming to contractors, the code provisions when it comes to contract workers apply to establishments or contractors who engage 50 or more contract workers under the code. So this code is applicable to any organization that employs 50 or more contract workers also. It also applies to any organization that employs 10 or more migrant workers. Or this includes migrant workers as contractors also. There are specific exclusions under the code. So, government and sovereign function entities such as offices of central state government, defense, atomic energy, space, military, etc. But this also includes railway running sheds, hotels, restaurants, eating spaces, uh, prospective only my home base BD cigar works where specific provisions under the code are provided.
Just I want to add here why they are exempted. Just I want to explain the analogy because this government organization they have better schemes of social security and health safety conditions, so they are exempted from the code. For example, in government establishment, they have maternity leave for 3 years, or the graduate limit is also on higher side when they are working as a government unit or an organization. So they are exempted from the code. So the logic behind, if you are getting more benefits under the central government or state government laws, you are exempted from the code. That is the philosophy while exempting this organization from the code. Yeah, thank you. Go ahead.
Yeah, then doesn't apply to institutions for charitable, social, or philanthropic services or domestic work. Then armed forces are excluded. Police, prison staff are not covered under the definition of worker and employee under this code. Then when it comes to, however, when it comes to any contractors that are engaged by the government offices, those are included under the code, even though the government offices themselves would not be included under the code. Now, the government has a discretionary power to exempt any establishment or class of establishment. They can also exempt new factories, but because the code has just been notified, but they have the power to do it. Then during public emergencies, they can provide exemptions. Educational and research workshops can get exemptions under this code. Coming to uh, the main definition under this code, which kind of defines the applicability of this code on organizations, so which is establishment. Now, it is any place where industry, trade, business, manufacturing, or occupation is carried on, and in which 10 or more workers are employed, specifically to include motor transport undertakings, newspaper establishment, audiovisual production, building and other construction, plantations, etc. Like I mentioned, even if categories of organizations where even one worker is employed, like for example, mines, ports, organizations doing hazardous activities, that is defined under the code in the schedule, then they are um, then their establishment and this code applies to them regardless. Now, when it comes to, say, for example, bigger companies that may have support functions in their organization, so I'm talking about security, canteen services, laundry, gardening, etc. Now, if this is not the core activity for that organization, then it may not be considered as a separate establishment under the code, separately, but under the entire organize itself will still be an establishment. Like I mentioned, this excludes government offices, and certain military, sovereign and social services, etc., under this code. Coming to employees, so employees, we have covered this in our earlier webinars also, because this is, like we had mentioned before, the definitions and all are quite uniformed over the four different codes. So an employee is defined as any person employed on wages to perform any skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical, or any other type of work. So it is quite a universal definition when it comes to an employee. It also applies to any person that has been employed, is in employment either expressly or in an implied manner. Then there are special provisions, provided for mines, where there's an expanded definition. I will just not go too much into detail in this, but for mining operations, you have various functions that come together to undertake the activity. These include repairing machinery, where anyone providing welfare, health, sanitary services in at the mine, any services for development of the mine, etc. All of that have also been covered when it comes to employees for a mine. Now, sorry, there are key exclusions also under the definition of employee, which is apprentices, that and armed forces, that have been specifically excluded under the definition of the employee. Coming to the definition of a worker. So now there's just a slight distinction over here. So employee is more universal, where we can say worker can be more of a subset of an employee. So when you talk about a worker, it is defined. A worker is defined as any person employed in an establishment to perform manual, unskilled, skilled, technical, operational, clerical, or for hire or reward. This definition applies even if the employment is in an implied manner. There are specific inclusions under this definition, which includes working journalists and sales promotion employees, which wasn't there before. And exclusions include military personnel, law enforcement, and um, it includes any person who is in a non-managerial or administrative capacity, earning less than 18,000 per month. So that's the difference, where employees can be in a managerial, administrative capacity. Workers are not that. So again, a worker as a definition was different for different acts earlier, which has now been kind of streamlined and turned into one definition. Coming to an employer, employer is defined as a person who employs one or more employees in an establishment, whether they do so directly or through another person, or on behalf of themselves or others. So if you're employing yourself, if you're employing for someone else, or if you're employing anyone through someone else, all of that has been covered. For government departments, specifications have been given for local authorities. You have the chief executive. For factories, you have the occupier, who is considered the employer under the code. Then for mines, you have the owner of the mine. Any kind of other establishments, then you're looking at person or the person or authority that has the ultimate control over the affairs of the establishments will be considered an employer.
Somebody has
So
actually put up a question. Under the exclusion of the domestic work, plus clarify the following. There are many agencies who are actually providing domestic worker directly to a household work. Are such agencies covered under the definition of the establishment, and are they covered under the new labor code? That means people who are actually providing security services, other things,
They are
etc.
covered, Mr. Bala. They are covered because see, the law is given, code is given exemption to a household. Suppose I am engaging in my house less than 5 employees. Okay, then my household will not be covered under that. But
Okay.
tomorrow, if I'm running an agency and I'm providing 1,000 employees to various households, to various societies, then this is a typical commercial activities that I'm going to carry on. Okay. So I will be just because, see, again, it is not because of your nature of services that you are providing, it based on number of employees that you are hiring. So if you are providing these services to various societies, various household, and if you are having 5 or more employees, then you will be covered under the code. And
Does the exemption given to the charitable institution apply to the school and its employees, which are run by these institutions, irrespective of the number of employees?
Yeah, see, government organization, as mentioned by Kinjal, they are already excluded because they have better scheme of, the safety, health, and social security. So they are excluded. So there are two type of government school. One is aided and unaided. So if it is, aided by the government, some from in the form of subsidies, then they are exempted from the code.
What is the logic to exclude the hotels, etc.? Logic to exclude hotels, etc. That is the question put up.
See, they are not excluded. They are covered, but there are certain different working conditions that has been prescribed under the code. Even Maharashtra Shop and Establishment Act, they have different rules to carry on hotel, restaurant. There are different provisions for. They are not. So they are either they will be covered by state law or they will be covered by the code.
Please explain legal representative into bracket a deceased employer.
Suppose I am running a sole proprietorship and on my death, my heir will be liable for the workman dues. So the contractor and this deceased employer, they are recently added in the definition of employer. They were not there in the earlier labor laws. So deceased employer means legal representative means the person who is handling my business. So my successor is responsible for payment of any dues to the employees.
How to interpret the managerial or administrative or supervisory role in the definition of the workers? Is there any guidance or interpretation, or it can be a judgment?
No, they have given very clearly based on the salary limit and the nature of duty. So the manager will be designed, is regarded if you are having really manager position like, approving of leave, sanctioning of payment, or sanctioning of promotions, or taking disciplinary action, then that person will be considered as manager.
Yeah, it was there actually earlier also, in the earlier code also.
Same analogy they have used.
Because what happens is people used to get away by designating even the telephone operator as saying the frontline manager. They used to do like that. Telex operator, they used to say, communication manager, something like that. Because the whole idea is they are actually prohibited and join the trade union. They should not get involved and other thing and all. And subsequently, they used to be terminated. I have seen one of the cases where a telephone operator was actually designated as a manager and she has been terminated. And then she went to the court. the court exercised exactly this questions only. If this person is having any authority to sanction any leave, whether she can approve any expenses, whether she can supervising somebody, whether she is actually having somebody working under her, all those things have been examined. Ultimately, they said irrespective of whatever your designated immaterial, she comes under the workers category only. She will be reinstated with the back wages. So that is the test. Even that was there. Even today, that holds good.
Yes,
Yeah.
yes. And NGO and
Yeah.
trust, they are included, they are not excluded.
Yeah.
It is applicable to NGO and trust as well.
Yes, go ahead, Kinja.
Coming to a very important definition, which is definition of wages, which we have covered earlier. So I'll quickly just run through it. Wages includes basic pay, diurnal allowance, retaining allowance only. Anything over and above that is, will come under the 50% rule, where if you have bonuses or end of service payments, allowances for amenities, expensive employer contributions and special pay, then these can be capped to a 50% under what is called wages. This cannot exceed 50% of your total remuneration. Any excess amount becomes any amount from excluded items that goes over 50% limit is added back and is counted as wages. We have discussed this in depth in our previous webinars. Coming to contract labor is hired through a contractor for work for an establishment. This applies whether or not the main employer knows about the hiring or no. So it is extremely important that the main employer must know all the vendors that he is engaging, whether such contract labor is taking place or no, because the ultimate liability will be falling on the contract labor. Um, Contractors, interstate migrant workers have also been included under this contract labor, and the exclusions under this code includes a contractor's regular employee staff with permanent status, regular pay, raises, benefits are not included. So these are the employees of the contractor himself that are with the contractor on permanent basis for his establishment in a sense, and not employees that are working for another establishment for regular main employer. Defining a contractor is a person who produces a given result for an establishment. The given result is to be achieved using contract labor, and this has been differentiated by not just supplying goods and services in another manner, but actually supplying contract labor under the code. And it also includes a subcontractor, a person who supplies contract labor as a human resource. This definition has also included subcontractors in the particular process under the code. Definitions for I failed to mention earlier. When it comes to contract labor, any establishment is prohibited to contract out its core activities under the code. Permitted exceptions could be, if there is intermittent or seasonal sudden decrease in volume of work that comes about for any establishment. Now, any so the contract labor regulations apply to establishments or contractors that have employed 50 or more such workers on any day in the preceding 12 months. The responsibility for wages, benefits, working conditions provided, etc. The ultimate responsibility for all of this, like I mentioned, falls on the main employer that engages these contract workers. Coming to interstate migrant workers, they are defined as a person employed in an establishment who have been recruited directly or by an employer directly through through a contractor in one state for employment in an establishment situated in another state. There could be self migration also, where they have come on their own from one state and obtained employment in an establishment in another state. Or have they have subsequently changed establishment within that destination, where they are working under an agreement or an arrangement for such employment, and they are earning wages not exceeding 18,000 per month. They need to be, they can register themselves with their Aadhaar card and avail the benefits and protections under the code that have been provided. Like I mentioned before, there is a shift in the inspection and enforcement under the code, where before we only had an inspector and there was a lot of nuisance being created. They had a lot of discretionary powers and all that was many a times misused, which created a nuisance for establishments in India. But now we're looking at inspector cum facilitator, who has a dual role to advise on compliance and also conduct inspections, etc. The code also defines hazardous processes. It's a process a process is considered hazardous if waste or effluents generated by an industry. There is a list that has been provided in the first schedule, uh, where waste or effluents are generated by an industry that cause material impairment to the health of persons engaged in or connected with the work, and which also results in pollution of the general environment. Now, the first schedule lists some 40 industrial categories with hazardous processes like metallurgical industries, chemical and petroleum, etc. Cement, lintering, tanning, manufacturing of cement, leather, tanning, rubber, glass, ceramics, etc. So all of these hazardous processes have been specified in Schedule 1 of the code. Central government have waived this 10 worker threshold. If you have even one worker, you're required to register under the code, and the code is applicable for such establishments. Compulsory disclosure requirement has also been put in place, where occupiers of factories involving hazardous processes must disclose all information regarding health hazards and safety measures to prescribed authorities, to its employees, etc. We'll get into this a little later. Now, for safety and health oversight, any factories having with 250 plus workers must appoint safety officers. Occupiers must maintain medical records and safety measures to workers. There must be emergency standards, and if that would be prescribed by the government, and if there's any failure in that, there's a penalty for that. Now, under this code, if this code is applicable to you, where you have 10 or more workers in your organization, then you're required to register under this code within 60 days of this code being applicable. For registration purpose, the factory uses the 10 worker threshold, even if other parts. So, like I mentioned, factories are also establishments under the code and require registration. Now, if there are any hazardous processes that are being undertaken in the establishment, then regardless of the 10 worker threshold, you're required to register. The process has been digitized, and they must apply electronically within 60 days. And they will receive the electronic certificate. If this is not received by the establishment within 60 days, then it would be deemed approved and registered. Then late applications can also be, taken in, but with additional fees under the code. If there is any changes or updates, like the management has changed, any other details, key details, they must be reported electronically within 30 days for the certificate to be amended. If the establishment is getting closed, the authorities must be notified within 30 days, um, and certify all dues of workers have been paid within the 30 days. Then, deemed cancellation. If the officer doesn't cancel the certificate within the 60 days of receiving the closing notices, it is deemed closed under the code. If there is no registration, an employer is strictly prohibited from employing workers if their establishment is not registered, or if the registration has been revoked or cancelled. So, under the code, if you have not registered, the, and if you're employing employees over 10 employees, then that's illegal. You are mandatorily required to register, and you're not allowed to hire people if you haven't registered. If there is, any suppressing of material facts that have been discovered when it comes to registration, then it can be revoked. There's a 30-day appeal window for that. And also, if you're already registered under the old code, then you're deemed valid registration under this code, but you must provide details under the uh, new code to the registering officer in the prescribed format. An employer can apply for a single electronic license for a factory, BD cigar, work, contract labor, and if again, like if it's not received within 60 days, then it is deemed received under the code. Now, this code essentially functions in the form of responsibilities. So the code essentially highlights responsibilities of various stakeholders in the establishments. So we're looking at responsibilities for employers, responsibilities and rights of employees, and other stakeholders involved in the organization. Coming to the responsibility of the employer, which is the most significant under the code, we're looking at various responsibility when it comes to administration, safety and health, physical environment, welfare infrastructure, finance and transparency. Coming to the administrative related responsibilities, once the code has become applicable, they are required to make the registration under the code within 60 days. Further, the code mandates issuance of appointment letters. Within 3 months for existing employees, and for any new employees on appointment, they are mandatorily required to issue appointment letters. There are prescribed requirements when it comes to content of such appointment letters, being type of work, hours of work, etc. Then when it comes to employers are also mandated to issue wage slips to workers under the code. When it comes to registers and returns, so like I mentioned before, maintenance of registers have become electronic, and it has been streamlined, which earlier different registers were maintained under different acts. We're looking at under this one particular code, you're maintaining registers for worker particulars, hours worked, rest days, wages paid, leaves, dangerous occurrences, etc. Now, there are certain industry specific registers also that are mandated. For example, for mines, for BD and cigar workers, for hazardous processes, plantations, etc. Now, these inspector cum facilitators have the authority to access and seize, take copies of these registers, um, and they are more or less confidential property of the establishment, essentially. But if the facilitator cum inspector thinks that it needs to be disclosed, then he can ask the company to disclose. Return filing is again the responsibility of the employer, but this has been more streamlined, like I mentioned, than before. We will get more information on various returns and processes for filing returns once the rules are put out. Coming to general safety and health duties. So every employer is legally bound to maintain a safe and healthy work environment. They are required to provide a hazard-free workplace where the workplace is free from hazards that cause or are likely to cause injury or occupational disease. They must also comply with all occupational safety and health standards declared by the government or which is specified under this code. Then there are safe systems of work. This includes provision and maintenance of plant and systems that are safe and without risk to health. Then, when it comes to knowledge transfer, employers must provide information, instruction, training, and supervision necessary to ensure that health and safety of all employees is taken care of. They must also provide all places of work must be maintained in a safe condition with safe means of access and egress. Then the employer is also required to provide universal health working conditions standards. The work Employers must ensure cleanliness, hygiene, proper ventilation, and temperature control under the code. There must be separate hygiene, latrine, and urinal accommodation for male, female, and transgender employees. The provision of potable drinking water, adequate lighting is primary duty. Employers are responsible for effective treatment of disposal of hazardous and toxic waste, including e-waste and effluents. They are required to prevent overcrowding in the establishments. They are required to provide proper sanitation, washing areas, etc. under the code. Then coming to mandatory welfare facilities and thresholds, the code specifies several facilities that become mandatory based on the number of workers ordinarily employed in an establishment. So you're looking at canteens being mandatory in establishments employing 100 or more workers, including contract laborers. Establishments with more than 50 workers must provide a creche facility for children under 6 years of age. Like we mentioned in our earlier webinar, the code allows establishments to pool resources or use a common facility to provide facilities that may be provided by governments or NGOs to meet this requirement. It's not necessary that the establishment itself should make a creche facility available, but at the end of the day, the creche facility should be available for establishments with more than 50 workers. Separate shelters, restrooms, and lunchrooms are required in every factory and mine with more than 50 workers. Ambulance rooms, these must be provided in every factory, mine, or construction site employing more than 500 workers. Every factory, mine, or plantation with 250 or more workers must appoint a qualified welfare officer that ensures that these welfare facilities, are provided to all the employees and workers in the organization. There are certain sector-specific welfare mandates also. So, for example, mines, employers must provide for medical examination of all employees before they start work and at specific intervals. For plantations, um, the scope for welfare is significantly broader, where it requires employers to provide housing accommodation with kitchens and toilets, educational facilities for workers' children, if the children are more than 25 in total, and recreational facility. For building and construction, employers must provide free temporary living accommodation at or near the workplace for work site for all building workers, so etc. So there are specific welfare mandates for specific industries under the code. Then coming to reporting and mandatory reporting and disclosure. um, so under this code, we are looking to provide a lot of transparency between the employer, employee, and the enforcement authorities. We're looking at incident reporting, and employers must notify prescribed authorities of any incidents resulting in death or bodily injury that prevents an employee from working for 48 hours or more. When it comes to dangerous occurrences and diseases, notice must be sent for specified dangerous occurrences and for any employee contracting a disease listed in the third schedule. There are certain diseases such as lead poisoning, abscessosis, etc., listed in the third schedule. Then, if these kind of dangerous occurrences and diseases have been contracted by the employees, then the notice must be put up. Um, hazardous process disclosure for occupiers of factories involving hazardous processes. They must disclose all health hazards and safety measures to workers, local authorities, and general public in the vicinity. Coming to the financial responsibilities, so all of these welfare costs that the employer needs to undertake for its employees and workers will be at zero cost to the employee. All the costs will be borne by the employer. There would be no charge for safety. No fee can be levied on an employee for anything provided for occupational safety, hazard maintenance, including medical examinations of protective equipment that are provided. And employers must provide free annual health tests to prescribed classes of employees. There are certain employees that have been codified under the law, such as in mines, etc., that need to be provided free annual health tests. For overtime wages are provided at twice the ordinary rate. Contract labor wages, if, like I mentioned before, if the contractor fails to pay the wages, then the principal employer is finally responsible for the payment of wages for the contractor employees it employs. Special regulations for contract labor. So contractors must obtain a license to supply or engage contract labor. License is valid for 5 years. If a contractor does not meet the general criteria for a license, then they may be issued work-specific license, renewable for the duration of specific work order. Contractors cannot charge any fees or commission directly, indirectly from contract labor in any shape or form. Payments to the contract labor must be bank transfer or electronic mode. Then the coming to health and safety and welfare of these contract workers. Principal employer is responsible for providing facilities, welfare facilities, safety, etc. They're working on that premises. Employers are responsible for safety and health of everyone on the premises, including contract laborers, and must ensure workplaces free from hazards. Coming to interstate migrant workers, Like I mentioned, they're included in the contract labor, included as contract labor. They can register themselves on basis of self-declaration and Aadhaar and take the protection that they have under this particular code. They must be earning less than 18,000 per month and recruited from another state. Employers of establishments with 10 or more interstate migrant workers must provide specific facilities such as reporting fatal accidents to authorities in native and destination states, and also providing a lump sum fare for to and fro journeys for the workers' native place. Coming to portability of welfare benefits. So just because you're a migrant worker under different states does not result in any kind of loss of essential protections and services under the labor compliances. So we're looking at a public distribution system where governments may create schemes that give interstate migrant workers the option to avail public distribution system benefits either in the native state or destination state where they are currently employed. Now we will get some more clarity when we get more rules that are notified by the central and the state government. There are also the appropriate government may also provide a toll-free helpline to assist interstate workers with grievances or any kind of information that they need. There are various sector-specific provisions also, which previously were under different acts, have been now kind of compiled under one code. There is separate provisioning for audiovisual worker, which are these workers who are artists, actors, musicians, singers, anchors, newsreaders, dancers, dubbing artists, and stunt persons. And it also covers any individual performing skilled, unskilled, manual, supervisory, technical, or artistic work related to the production. Now, to qualify under this definition, the worker's remuneration must not exceed amount notified by central government. It's not been notified yet. Audiovisual production includes animation, cartoons, advertisements, digital production, feature films, sport shows, talk shows, etc. There, under this code, it is a mandatory requirement to have a written agreement which has been finalized between the parties. So, and this agreement must be registered. And if this work has been done on contract basis through a contractor, then this agreement will be between the employee, the employer, and the contractor. Now,
This was some welcome move actually because there is a lot of unorganized labor in this industry. Yeah.
yes, you recently we also had Deepika Padukone and all speak out on this. Then the code also kind of specifies the contents of this particular agreement, which includes nature of the assignment, wages and other benefits, health and working conditions, safety measures, hours of work, welfare facilities, dispute resolution process, etc. Now, producer is liable to discharge all of the welfare, wages related obligations under this code and under the agreement. In case of any dispute resolution, they can go to the industrial tribunal for any kind of conflicts. So, like I mentioned, the tectonic shift when it comes to the inspector come facilitator model, where the inspections are to be done and selections of establishments for such inspections are done in a web-based randomized manner. And so a lot of discretion that was there with the inspector has now been taken away. And third-party audit requirements for startups have been introduced. Due to paucity of time, I cannot, go into all of this. But we are looking at old model, which was policing, which has now shifted more to advisory under this code. Coming to the penalties, like we mentioned, penalties have increased exponentially, where they've been kind of divided. I'm just covering the main penalties here. But in case of general contravention, we're looking at a fine of 2 lakhs to 3 lakhs. Any kind of obstruction of inspector, we're looking at up to 3 months of prison or 1 lakh in fine. Falsification of records, up to 3 months in prison or 1 lakh in fine. Violation lead to death, up to 3 years, up to 2 years in prison, minimum 5 lakhs fine. So we can see that any kind of serious offenses have imprisonment as an option that has been provided for to enforcement authorities under the code. But in case of general contravention, it is limited to only fines. Also, violation when it comes to hazardous activities leading to death, etc., have been taken up very seriously under this code. Any kind of falsification of records, again, is considered a serious crime under the code. Inspector, a serious crime under the code. Now, like I mentioned before, for first offense, inspector must give 30 days to the establishment to comply before the prosecution begins. Now, coming to the expected impact of this particular code, we're looking at consolidation of laws. There's a shift in compliance philosophy from prescriptive to risk-based. Prescriptive, we were looking at checklist based under various different laws, various different authorities, various different inspectors, etc., which is now shifted towards more responsibility based compliance requirement, and it's less checklist based, more um, accountability based philosophy of compliance under the code. Then we are looking at expansion of accountability beyond employers. Like I mentioned, the code now includes designers, importers, engineers, architects, etc. also, and they have shifted certain liabilities on them also. But at the same time, the employers have been always maintained to be the main parties that are accountable for the labor law lapses. We also looked into impact on ease of doing business, where processes are streamlined, compliance is more streamlined, returns filing, registration, and things have been made much better, allowing for ease of doing business. The inspector come facilitator model it has been introduced to facilitate ease of doing business, but at the same time, the requirements under the code are way more stricter. Accountability and responsibilities have been properly explicitly provided under the law, and the coverage of various types of employees have also increased under the law. Like I mentioned, informal contract and migrant workers have been included under the code, and the protection has been provided.
Teacher, how many more slides?
This is the last one. High risk and hazardous industries have been taken way more seriously under the code, where these kind of provisions were only sector specific. They are now more uh, they are more universal, as long as you're looking into hazardous processes. There's impact on enforcement and governance. Like I mentioned, state and central government will have codified duties. The inspector come facilitator model is more centralized, etc. Impact on corporate governance and ESG. The accountability responsibility is shifted more upwards towards the board, which was earlier just an operational issue. There will be transitional and short-term challenges. For example, the code has just been notified, in November 2025, but then looking at without any kind of breathing space provided to the establishments to actually put in place capacities and systems to come and comply with the code. So everyone's kind of scrambling to comply with the code, trying to understand the code, which is causing a bit of anxiety when it comes to different establishments in India. Again, there are a lot of ambiguities because the rules haven't been published yet, and we're looking to this ambiguity in terms of what applies, what doesn't apply, etc. So this is just a short-term thing, but I think going forward, I think this brings India in line with global labor code standards and requirements, which is very essential given how much we are integrating with the rest of the world today. Thank you.
Good. Thanks. You can take now pause and rest. Mr. Bala,
Yeah.
you can start.
Excellent, Kachal. Very nicely presented. One thing is there, one of our senior members, Jambunathan, has actually puts it very clearly from the implementation perspective. Although code talks about lot many things and the implementation, etc., when it comes to the implementation, especially with the SME and the MSM units, it is their capability to ensure their digitalization, their preparedness, and other things. That is what he has mentioned is reasoning. So these are all the concerns which are actually there over the period of time. I think it will get addressed. That's what I also feel actually. But only thing is, as Kinjal time again puts it very clearly, the rules by the various states, they are still to be notified, which is not there. But for all the information of the people, the current rules which are actually there, that will continue till the new rules come into. But whatever the new code has already come into implementation, wherever the majority of the thing which has been applicable, that is universally, that has to be implemented. People raise the various questions whether the model standing order is to be modified. Of course, it has to be modified. You know, to get inbuilt all those provision which will come with the new code, especially with the 50% labor laws and working timings and other things and all those things, to actually get it modified. Those are all the things which are there. Okay, let us take the question here. What is the threshold of the employees for registration under the contract labor? I think that we have discussed really. I have an organization I contract with my agency who provide skilled employer on their payroll to my clients. In such a cases, to my clients for providing manpower at the agency build me and provide their skilled
Bala,
employees. Yeah.
Mr. Bala, this is very specific long question. It should not be attended. If it's a legal interpretation, they can write.
Okay.
They can put it as a crucial question only, not the entire facts. What is the law they want to understand?
Please clarify the meaning of the medical records.
Now, to be called as an establishment under this particular code and to have this code apply under the audiovisual sector, the establishment should have 10 or more workers, and the producer is defined as the company, firm, or person who undertakes necessary arrangements for the production, including raising of finances and engaging workers. In case of any kind of non-compliances, there are penalties that have been specified, which range from 50,000 to 1 lakh rupees. There are special requirements under the code for the mining industry, where the code also includes workers involved in the ancillary infrastructure of a mine, which is your borings, oil wells, shafts, open cast working, conveyors, aerial ropeways, etc. It has also included support facilities, workshops, stores, power stations, transformer etc. So as we need to understand, when there is a mine, it's essentially a village in itself with so many different functions taking place. So now this code attempts to cover all of these employees that are engaged in work when it comes to this particular mining activity. There must be a mandatory manager, where every mine must have a sole manager possessing qualifications prescribed by the government, who is responsible for the overall management, control, and direction of the mine. And every mine must appoint this particular sole manager, otherwise there are penalties stated under the act, under the code. There's the concept of owner and agent. The owner is the proprietor or lessee, and the agent is anyone acting on behalf of the owner in the management. And they are jointly and severally liable for providing the financial and structural means to comply with the code. Um, then mines have specialized working conditions that have been mentioned, where there are certain restrictions on working hours. There must be system of shifts that must be there. A register of workers must be mentioned. The shifts, there cannot be any overlapping shifts. There cannot be double employment. Annual leaves have been mentioned, where you have 1 day for every 15 days below ground, because you're above ground or below ground in mines where working conditions are very different. So there have been specifications for that. You have safety committees and officers, which are mandatory for mines employing 100 workers or more, where even safety officers must be appointed. Welfare amenities, shelters, restroom, lunchrooms are mandatory for mines employing more than 50 workers, ambulance rooms for 500 workers, medical examination before they're employed on regular intervals, etc. Welfare officers for mines with 250 workers or more. Then there are restrictions on and prohibitions on employing individuals who are below the years of 18, below 18 years of age. Any kind of apprentices and trainees not should not be below 16 years of age, etc. There are certain there are several specific requirements for plantations also, where employers must provide housing facilities, including water, toilets, educational facilities for children. Like I mentioned before, if the children's exceeding 25 in total, and training for workers handling toxic chemicals, etc., that have been codified under the code. Again, there are specific requirements for BD and cigar establishments, where they must hold a valid license to be able to function. Run an establishment for BD and cigar. And there are required labor welfare criteria for such BD cigar establishments also under the code. Now, moving from the responsibilities of the employer to the responsibilities of an employee, where responsibilities and rights actually. So when it comes to responsibilities and duties of the employee, they must take reasonable care for safety, where every employee is legally required to take reasonable care for their own health and safety while at work. This duty extends to the safety of other persons who may be affected by the employee's acts or omissions in the workplace. So, this is something interesting, that an employee that if his actions are putting other employees in harm's way, and if he lapses taking care by and fails his duties and responsibilities in taking care reasonable care of the health and safety and work requirement, and it may affect other people, then he's legally liable under this case. Then, compliance and cooperation. Employees must actively support the safety infrastructure provided by the employer. They must adhere to standards that are there. Employees must comply with all safety and health standards and follow instructions and training that the employer is mandated to provide. They must cooperate with the employer so that establishment can meet its statutory occupational safety hazard obligations. Employees are strictly forbidden from willfully interfering with, misusing, or neglecting any appliance or safety device provided by the health and safety purpose.
Kinjal, try to finish in another next 10 minutes. We have to give now time for question answer also. Okay?
Okay.
10, 12 minutes.
Yeah. They are required to report unsafe situations, or any kind of situation that they may consider unsafe or unhealthy to the employer or health and safety representative as soon as possible. Yeah. Then coming to um, rights, they have right to information. They can obtain details on health and safety at work. If they feel there's imminent danger, they have right to report fear of serious injury or death to safety committee or inspector. The code also standardizes and codifies working hour requirement. So no worker is required or allowed to work in any establishment for more than 8 hours in a day. I'm specifying workers. This covers workers, not all employees. Um, so there's a general limit of 8 hours a day. There are specifications for mines, working journalists. So for working journalists, they're subject to a maximum of 145 hours of work during any period of 4 consecutive weeks. Then there's a 6 day limit. Workers generally cannot be allowed to work for more than 6 days in any one week. If then there is a concept of compensatory leave, where if the worker is being deprived of a weekly holiday, then the employer must provide a compensatory holiday of equal number within the same month or the 2 months following. Then there is night shift requirement, where weekly holiday for is defined as period of 24 hours for 24 consecutive hours beginning when their shift ends. For overtime work and wages, there's premium pay of twice the rate of wages, where consent of the worker is required for any kind of overtime work. The government may come up with limits on overtime work that can be done. Any overlapping shifts are prohibited under the code. Coming to annual leave, the code provides a structured system for earning and utilizing paid leave. The worker must have worked at least 180 days in a calendar year to be entitled to leave with wages. The code provides certain dates and days. So you have 1 day for every 20 days of work. For adolescent workers, 1 day for every 15 days of work. For mines, you have 1 day for every 15 days of work. Now, carry forward and encashment of leaves. Workers can carry forward up to 30 days of leave to the succeeding year. They are entitled to encashment of leaves at the end of the calendar year or when the total exceeds 30 days. For journalist and sale promotion employees, they have specific leave entitlements, including earned leave on full wages, and medical leave on half wages. Then, yeah, I'm just going to rush through a little bit given the paucity of time. Then employers must correctly display and maintain notice clearly showing the periods during which workers are required to work. Any change in the system, they are required to maintain registers when it comes to hours of work, days of rest, leaves taken for every worker.
Sandeep?
Yeah. So medical record, that is in our Factors Act, they have given a prescribed format called Form number 7, which has all the histories of the employees that has been checked up by the certifying surgeon. So medical record means the typically the annual checks that the company is conducting right now. So that cover in the that comes under medical. For example, blood test, eye test, you know, hearing capacity loss. So all those forms under the medical records.
Yeah.
And there are 4 codes of the labor code. For each labor codes of 4 codes, separate registration will be taken or one will be sufficient.
One will be sufficient. There will be one registration only, which will be applicable to all the codes. So we will get one unique number, which will be applicable under all the codes.
Registration on the OSH within 60 days and of implementation of the central rules or implementation of the labor codes.
Yeah, within 60 days, we have to register. Once the final rules are notified, we have 60 days time to register, or we can convert our existing number into number allotted by the code.
Will registration under any one of the subsumed acts automatically get registration under the new labor codes?
Yes, that will be used as base. As you know, we are having earlier service tax, so that have converted into GST. Similarly, the existing provident fund number or ESS number, they will be converted into a new number under Social Security Code or under OSH Code.
Okay, thank you, Dipti ma'am. Thank you, Dipti ma'am, for it's very wonderful. Okay, this is acknowledgement, appreciation, which is actually coming for you.
Yeah.
Regarding issuing the appointment letter to the existing employees, should the letters be issued with the current date or it will be original employment date?
With the current date. So they have in the rules they have given the formats or the points that needs to be mentioned in the appointment letter. So you can add those points. You can have your own appointment letter, but you need to add those points given in the rules like Aadhaar card number. They have given a list of 10, 15 points that needs to be added to the appointment letter.
Yeah, appointment letter is generally designed by the employer and the employee under the contract act actually, but only thing is the labor code says the appointment letter must include certain mandatory requirement which one have to actually built in, and each organization can modify their own appointment letter according to the requirement, nature, industry. That is what it is required. Whatever the mandatory requirement is there, that has to be built in the appointment letter.
You can refer to your original employment letter so that employment date doesn't change. Only thing that as per rule you are changing now is up.
Yeah, that is right. That mandatory requirement is to be built in to that extent. That's all. Otherwise, your employment contract appointment letter will remain as per the organization's way only.
Right.
The mandatory requirement is to be included. In case of the shared crutch facility, who will be bear the cost of the such shared crutch facility? Does the employer 20? Does the employees reimburse the employer or crutch fees charged for the carrying their children?
See, the crèche facility, if you see the law, it is the responsibility of the employer. In case of shared crèche facilities, they have to put their share because, we have various co-working space, in Pune, Mumbai, or in various metro cities. So they will take as a part of their lease rental and we can use those facilities.
Sandeep, I have a question here. I don't know. Correct me if I'm wrong.
Yeah.
When I was glancing through the rules, I also saw either the employer has to provide the crutch facility or they have alternatively, paying a child care allowance up to the 2 children or something like that.
Yeah.
That was actually there.
So that is the industry practice, sir. That is the industry practice that is not been provided in the law. Because see, crèche facilities, people or employees, they want near to their residence.
Correct.
Right. No one will bring their kid to their office and, they will use the crèche facilities.
Yeah.
So, to facilitate this, many companies, they have started paying daycare allowance or as rightly mentioned by you, child care allowance. That has been provided by many companies. But, what I suggest, you have to have a tie-up with the crèche facilities. And this can be used as a justification that we are not providing crèche, but we are taking care of the well-being of their kids. So the time will decide whether this is acceptable to the authorities or not.
Yeah, because specifically in the rule, this or that.
Yeah,
that is actually not there.
Yeah, yes. Correct.
Because it only talks about the.
We cannot assume that, and that's why I said it's the industry practice. We cannot assume that.
Yeah. Okay. Okay, this is what relating to the crime. There is a distinct factor of 1 kilometer. Yeah, same thing he is talking about near
Yes,
the house and
we
above the
have
house and nothing,
answered this.
which
Yeah,
you
we have.
actually address this.
Yes.
Sometimes contract workers are from Nepal. In such a cases, what is the document verification need to be submitted?
Sorry, sir, what is the question?
Sometimes the contract workers are from Nepal. What is the document verification needs to be submitted?
Same, sir. Aadhaar card, PAN card. These are the documents we are using for KYC. That document we need to be. That has to be used.
Here there will be a problem will be there. I do not know, because when we say the person has come from Nepal, then probably you have to fulfill certain requirement for getting the Aadhaar card, PAN
Correct.
card in our
Correct.
country and
Correct.
all those things.
Yes.
Those
Yes.
problems will have to be there. That is
Yes.
one thing
Yes.
I feel. I don't know. Okay.
Yeah. Because, sir, why
Okay.
I'm saying this, because if you want to claim any benefit under the code, any code for that matter, code on wages, code on social security, they have based Aadhaar is the, I mean, they have made all the claims are Aadhaar based. So that is the main document under the code.
What
For
is the
from
employer? Yeah. What is the employer's liability to provide PDS benefit to the interstate migrant workers?
that I think Kinzel has covered in her presentation, like, the portability, the travel allowance, and the facilities, she has already covered in her presentation.
No. Here, I don't know. When he says PDS, it is a public distribution system benefit. That's what he is talking about it.
That is ration,
Because,
ration.
yeah, ration.
Yeah,
So when it comes to
rice,
yeah,
sugar, oil,
yeah,
yeah.
So there he is asking a question: what is the employer's liability to provide this?
No. We have to provide that he is our employee and these are the documents, and he is not belonging to this state. He's from another state, so for him from Karnataka, he's from Goa, but he can purchase those things at this distribution system.
Yeah, because the thing is,
that the documentation and all that the concerned employee has to work, not that.
Correct. Not the employee.
We need any verification he can get from employer, but that documentation he has to do himself. No?
You're right, Dipti. Actually speaking, the employer has to provide the necessary documentation to provide he is a migrant worker, and the PDS system is done by the government. They will take care of it. But the employer's liability does not come, but he should not fail to provide the necessary documents to ensure he is a migrant employee. That's all.
He has to certify. He has to certify that he is a ISM. Interstate
correct. Yeah, correct. Under the section of the 53 of the OSH Code, it has been actually provided that the welfare facilities provided under section 23-24 will be provided by the principal employer. By understanding these welfare facilities, the responsibility of the principal employer, please clarify, is your presentation states otherwise?
No.
Our presentation also says it is the principal, because whether you apply the contract, whether you, whatever it is, the ultimate responsibility will remain with the principal employer only. Whoever is provided, that is immaterial, but ultimately the accountability and the responsibility goes with the principal employer. Even if the contractor provides the facility, the principal employer has to verify that necessary facilities are provided. The responsibility has to take care of it.
Correct.
Responsibility will be provided by that contractor. But if he fails, then that responsibility, even though that responsibility is of contractor, but ensure that ultimate employer has to. It is at present also the same situation.
Yeah, it was there earlier also, because earlier when we employ the people from the contract labor, he is covered by the Provident Fund, etc., ESI and other thing and all. What the employer used to do before making the next month payment, he used to call for the document whether the ESI contribution has been actually made, whether PF amount has been deposited. If that is not the case, the employer used to deposit that amount and deduct and make the balance payment to them. Even today also that is there actually. Yeah. One pertinent question regarding the contractor from the overseas client. What is the facility of the overseas customer who contracts outsourcing provide workers for a company in India?
I think it says the question. Subcontracting, what is the regarding subcontracting from overseas client? What is the liability of the overseas customer who contracts or outsource production work to company in India?
No, there is no liability on the overseas companies. There's liability of the company because we have to follow the law of the land. Okay, though they are outsourcing, we are utilizing facility here in India, so we'll be responsible for the employees engaged here in India.
So basically, the
saying
question will come that
he is talking about the IT industry. There is a question. Thank you. This
I
is
know.
what he is talking. I think last presentation, Kinjal specifically covered this IT industry. There was a question which was there. Your main business cannot be outsourced. This is what it is said actually. Last time Kinjal has taken up this. We had enough discussion. Whoever raised the question, please refer to the recorded version of
Mr.
the.
Bala, the question is, we are telling no that ultimate employer is the responsible. So that's why they are telling the contract is received by a foreign company and they outsource in India to another company. So whether that ultimate responsibility comes on foreign entity in India, whether under this code foreign entity is also covered, that is the question. Whether
No, then in that
jurisdiction, whether this law applicable to entity outside India also, if they are principal employer. That is the question.
No, this law does not have extraterritorial jurisdiction.
See, this law cannot extend beyond
The
India.
answer is no, because this law is applicable to land on in India.
Correct. So it is applicable only in our country. Overseas country, they have to follow whatever their country laws are applicable for them.
Yeah.
But
Yes,
at the same time, you cannot. So the idea of the ultimate responsibility falling on the principal employer was to avoid these companies outsourcing the labor law liabilities to some other contractor. But contractors are also covered as employers under the code. They cannot, even though the ultimate responsibility and all has been covered under the code, the contractors are also responsible to ensure that the welfare of the people in their organization is looked into.
Yeah. Next.
How is the workers' mental health taken care with OSH and working condition code?
How is workers' mental health?
Mental health. How is workers' mental health taken care under OSH and working
Means
condition
in
code?
health, you have not covered mental health, the code. That is the question. Yeah, we will test.
No. They might. Yeah, see, they are cover only physical injuries and all these things. So, so if there's an accident or death during the course of employment or in the course of employment, then only employer will be liable. So we are not responsible for his mental well-being, right? So, but out of mental well-being and he's disturbed and he do something wrong, then probably employer has to prove that that we are not responsible for his misdeed or for his misconduct. For example, take example of Posh, so he treat the other employee with some disturbed mind, and so we used to organize one counseling session on Friday when I working in IT. So counseling session can be arranged as a part of employee welfare, but that is not mandatory. So code is not providing for any provision or facilities for mental well-being of the employees.
No, here one more thing is there. Nowadays, very recently also there was a news item, people have been asked beyond record hours and all. There was a lot of discussion on the TV and all those things. And under the pressure, under the demanded, etc. In such a cases, they'll get actually stress and tension and other thing and all. That is what it is there. Probably this question could have been asked with relation to that. That's what I think. Anyway, code is actually more or less silent. Code is talking only about the physical health as such, I believe, if I understand correctly. How to document the consent of the workers for the overtime?
So we have to clear the document saying that this is the work time. I mean, we need to do overtime and give your free consent that I'm ready to work beyond my normal working hours. So
in fact, I don't know the companies where I was working. We used to have the overtime slip actually filled.
Correct.
We used to fill up the overtime slip. Their workers have to sign actually, I'm willing to work between this time to this time.
Correct.
Because whenever he comes in the first shift 7 to 3:30, we'll ask him to work for another 4 hours. So we mention the timing, he signs and we get it thing. So that sort of document, something like that. But law does not give the documentation format as such or something like that. But this has to be there.
Yeah, we can use, see, in Maharashtra Shop Act, there's a form L, consent of women to work, So that format can be used for overtime consent. That I'm ready to work. So that can be created.
Many companies don't offer leave, just leave encashment as a part of the CTC. Is leave encashment now mandatory under the new labor law?
Yeah, it is mandatory at the request of employee. So employee can, at the time of separation, it is mandatory. But if he's continuing the employment, he can request to the employer that he can give encashment on 31st December.
Please share yours. How can we actually fabricate the 50% basic CTC? It is a major and this. I think please go through the recorded webinar for the first session itself. This 50% rule has been talked very elaborately in that webinar. I am working in a government PSU. I am working in a position of the company secretary on a direct contract basis. The company, the other processes are streamlining the regular cadres for the various positions as the employees are employed through the outsource mode, except some employees who are in direct contract. That means FTE basis includes me. The social security benefit are not given to us, being not implemented in that time being. Is it under the process or may take some time? What would be the consequences in case the PF is not being deducted for few more days?
It's a too big question.
I'll tell you one thing. Let us not answer this specific question, but one thing is there. Even if the fixed term employment is there, the code applies actually. That is it. That is what we discussed actually. Even if the fixed term, even if the fixed term employment is there, it is the industry practice in some of the industries, especially what happens is, I have also seen it, the company secretary is employed for a period of 2 years, 3 years, contractual basis, etc., other thing at all. But that is only to get rid of, not to give the benefit, etc. But this labor code which has now come, it actually covers those things also. We would appreciate your clarification for the effective for the which companies to the PF ESI contribution required to be made on the basic salary only, whether the basic salary should be equal to more than 50% of the total remuneration. As per the recently released FAQ, the Labor Department, it has been mentioned that the new rules relating the gratuity ESI are already effective from 21st November.
And that's why in newspaper, all companies are giving the effect on the profit due to new labor code. This is the impact, and boss, that's why only this webinar has that at least though rules are not there, this is the most impact on financial aspect of the companies.
In fact, this has been discussed elaborately in the first 2 webinars. There were a number of questions were there, whether the financial is to be restated with effect from what date it is to be, whether the December close, all those things further. Please go through the recorded webinar. You will get a very clarity on this. Can you explain the core activity?
Yeah, core activity basically means the activity for which the establishment is set up. For example, I am involved into manufacturing of, say, kind of a software, or development of a software, or manufacturing of a cell phone, or manufacturing of a rubber. So that will become my activity. So we are all compulsory. So we know the main object that we put in the memorandum of association. So that become my core activities. And code I also give an example of what are non-core activities. Okay, so non-core activities typically means the supporting activities like housekeeping, canteen, courier services, construction, civil work, security, gardening. These are come under non-core activities. So typically the expectations of lawmaker that you can hire contract labor in non-core activities to protect the rights of the who are on the regular payroll of the companies. Okay.
That means simply what we open a company, say providing the IT services. What I do is I employ all the IT fellows through the agency as a contractual basis. I sit at home with the telephone, I do it. Nothing else.
That
is not expected now. Correct. The moment you say it is your core activity, that cannot be outsourced. Correct. It has to be your own employee.
Yes.
Whether the employer is required to register with the labor authorities for taking any contract labor under the labor code for contractor licensing sufficient.
If you are hiring 50 or more.
If I am supplying a skilled manpower to my client through
we
agency,
have covered this.
We have covered this. Now not separate provident
fund registration required.
Fund registration required as recorded in the present PF Act. No, PF Act is continuous actually. It is not totally merged with the labor code. Current PF Act, ESI code, and all those things which are actually there, which will actually continue. You have to comply with that. That is what we discussed. Even please refer our earlier seminar also on this when we talked about the first seminar. In this act, Kinjal ma'am talked about the leaves. However, currently every state has its own leave policy under the shop and establishment is not covered under the labor code. That is what we actually said number one. Number two is under the factories code. It is earlier it was about 240 days eligibility for the leave. Now the 240 days have been made to 180 days. That has come in the main law. So when that has come into the main law, every state has to give that benefit that you cannot vary actually. But however, it is up to the employer if they want to give more leave than that. If you have many organizations, it is there. Even the workers level, they say, forget about 240 days, 180 days, you will get 30 days every year. That sort of thing, the better facilities are given by the employer, that will prevail. Even in fact, Sandeep has said actually, the better facilities there, that will actually prevail. You need not go by this. You can always, provide more than what is law wanted actually. That you can always do it.
Shall I read?
Dipti, we are at 123, huh?
Yeah, that's why only I was telling. I think 3-4 question only. Is appointment letter is also required to temporary labor, like labor engaged in construction industry?
Yes. Yes.
Appointment letter is required. That
mandatory.
is
It's mandatory
now. Yeah, it is mandatory.
Whether existing certified standing order will continue to be valid or new standing
we
order?
Already discussed. No, it has to be modified. We already said that is nothing but it is a mod of standing order. Yeah. The biggest challenge is the code. This is what I said actually. Our senior member has put to the implementation comes to the MSP and other things about this that you will have to wait only time only will say. But anyway, there is no other go, but you will have to get, prepared for this. You will have to build your capacity. You will have to actually become capability or you will have to take the professional help. That is what it is there because law can only tell you what is required to be done. The implementation has to come actually within. That is the thing.
Okay.
We engage a GAG platform workers for our application-based company to provide services to the customer. After the code is implementation, GAG platform workers will become an employer worker please advice. Either a counseling, is there something difference between the GAG workers and the formal workers as per the labor code?
Yes, gig worker, they have created a separate category of the worker under the code. So their registration would be with the platform service provider like Ola, Uber, Swiggy, Zomato, Urban Clap. So they will be treated as employee of those platform providers, not of the company.
Would labor from Nepal come under the international workers category?
Yes.
In case of the foreign national, can secondment in India, what documents are required for him to have the Aadhaar card?
We have discussed, we have answered this.
Nepalese workers in India, legal position, somebody has actually given the things, whatever the treaty, etc. I think
I was supposed to tell, but this is a totally different law instead of our code subject. That when foreign national is there, what are the documentation? There are different laws and regulation covering that, employing the workers from outside. There are many things. FEMA is also many times involved. The treaty between the country and many things are there. So that's why it's a different altogether topic. So we are not going in detail. But still, Mr. Jambunath, thanks a lot for giving the answer in detail. Thanks.
Principal employees out of the India and the contract, this we talked about it. Mental health also we discussed about it. In this session, Kinjal talked about the leave under OSH Code. This also we talked about it. We have covered about it. Okay, thank you for clarifying my doubt. Whether overtime wages are required to be paid to the workers and employment under Section 4 of the Code of the Wages top and the workers are 27 of the OSH and the Karnataka Shop and Establishment. Don't mix up the Shop and Establishment Act with the code. Shop and Establishment Act is not part of the code. If you are under the Shop and Establishment, you are covered with the state laws. If you are coming under the code, yes, you are coming under the central with the rules by the state laws. Is it become mandatory to do F&F within 2 days if it is the employees for the specific employees?
It is for all.
This also is for all employees. We discussed this enough actually. If you please see our past session, we'll have. Do we need to come?
Yes, the answer is yes. Last question, do we need to comply with gratuity, LWPT? The answer is yes.
Yes. Yeah. I think we are done with it.
Yes.
So Any hands
We
is
have to
risen? Let
close.
me
No,
see.
no raising of hands, Mr. Bala,
Okay.
130.
Okay.
Because we are allowed and we answered all the questions, luckily, by rushing this presentation. Everyone is hungry and leaving the session. So, friends, thanks for your support. Thanks, Kinjal, for this wonderful series of 4 sessions, 4 quotes. Everywhere we are going, we have been appreciated for this, which was wonderful. Otherwise, I was wondering when I started, when Mehta started this series, that whether this will have a participants, as people may not, but we got a wonderful support from all our participants. And really thanks from entire Mehta and Mehta team for giving us the support for the topic, which is not generally taken by CS. Thanks a lot. Thank you, Mr. Sandeep, for your wonderful expert comment. And
Thank you.
friends, he is also CS. Please note that. So that's why this was the message we are giving. Yes, can do everything. Thank you, Mr. Bala. Thanks, everyone.
Thank you.
Kinjal, your presentation were actually excellent with the pictorial and other thing, and that totally you made it, so impressive and so interesting. In fact, I have been actually receiving a lot of appreciation for all the 4 sessions.
Thank
That
you.
is
Thank
it.
you.
Okay, you've done a great job.
Good job.
My
Good
great
job.
appreciation to you. Good job.
Thank you.
Thank
Thank
you.
you.
Bye bye.
Thank you, everyone.